Hi, Robin. How are you? Can you hear and see me okay? Want to make sure you can hear me and see me. Oh,
There it goes.
is that better? Okay. Yeah, when I logged on, it said your internet connection is unstable. So I don't really know why it said that.
Yeah, mine said that too. So I don't know, but now it's gone and it's
okay. Good.
So
Good. How's your day going?
Good. My mom came into town, so it was really nice. Got to have a visit with her, so it was awesome.
Excuse me. How long is she here for?
She got here last night and they already headed home, but yeah, it's like 103 here today, and it's just for all just dying.
Where are you at, Robin?
I'm north of Sacramento, so it's in Chico.
Okay.
Yeah, Chico, California. So
yeah, we had a heat wave as well. I think.
Yeah.
Excuse me, I have allergies.
Oh yeah, allergies are horrible here. Horrible. It's so bad.
It is. It's been really bad.
Yeah.
Excuse me. I know.
Yeah.
I went to the doctor. I'm like, I just want to make sure I'm okay, and they're like, yeah.
Yep.
Allergies. So.
I know, and it's so horrible here because we're in the valley, and with the rice fields and everything, it's just nasty. So yeah, we have all the almond orchards and all that fun stuff. So it's not fun at all.
Yeah, I'm sure. Yeah, that's got to be hard, especially if you have allergies already, you know?
Yeah, I had to have that sinus surgery a couple years back, and nasty stuff. So
well, was the surgery, did you feel like it was worth it? Like,
it has helped. I used to get probably like 4 sinus infections a year, and so it was horrible. I had so much scar tissue, and so now I still get, I probably get about 1 a year, but I just felt like I was on constant antibiotics, which is horrible for your system. And so, so at least that's, not the same anymore. So that's
absolutely good. Well, that's good. Yeah. Well, all right, we'll get started. I guess maybe it'll just be you and I, but maybe somebody will jump in, and when you get going. And so I'll mute, put mute on everyone. So whoever jumps in, it'll be a mute on everyone, and then I'll unmute at the end, and then we'll talk, just have a discussion. If you have any questions, let me know. Okay. All right, here we go. Let's see. All right, so we're going to start off with some common words. Get our fingers going. Okay. All right, here we go. Ready? Returned, during, lot, city, pretty, future, weather, need, came, forward, certainly. I like to write that as SERNL, so I don't know if you want to use that. Men, above, thanking, trust, sorry, pleasure, regard, written, past, yours, stock, away, life, rather, material, paper, high, why, further, fine, really, desire, taken, though, suppose, new, seems, several, satisfy, help, understand, bill, close, covering, guess, gold, room, sister, opinion, train, law, low. All right. Now I've got a phrase drill, and not all phrases will be phrased on your machine, but it's more like common phrases that you hear. So obviously, if you can phrase it, then I encourage you to do so. You're going to hear recall, which is final RL, and then recollect, I use final RK. All right, here we go. Ready? We should, this should, they should, there should, that you should, that should, that I should, that he should, so you should, so I should, so he should, she should, it should, I should, how should, he should, if he should, if you should want, should remember, should understand, should recollect, should recall, should have wanted, should have remembered, should have recollected, should have recalled, should have had, should have believed, should have been, should have, should feel, should be, should believe, she were, she would, she was, she wants, she wanted, she shall, she is, she recalled, she recalls, she recollected, she recollects, she remembered, she remembers, she should, she understand, she understands, she wanted, she wants. Right. Again, a lot of those you can't phrase, but you hear them in sentences, so it's good to practice them. All right, so now I've got a drill here that focuses on belief, believe, relief, relieve, and then leaf, leave. Okay. All right, here are your sentences. Ready? Did you believe his story? It is my belief that he is telling the truth. He is asking the court for relief. Did aspirin relieve the pain? Every leaf on the tree has fallen. What time did he leave the house? I believe that he was late yesterday. That is a strange belief. He is on a relief shift. What time did you relieve him? Press the leaf between the pages. The leaves are turning. It is a question of whether you believe him. His belief is strong. It was a great relief. Relieve the guard at midnight. Their beliefs are not the same. Her family always believes her. All right. And just so you know, you may already do this, but I like to phrase that he was as THAE, final FS. It's all the briefs you know. And then I think, let's see, that he is. Yeah, you can phrase that he is, THAES. So just pointing that out. All right. So now I'm going to give you a brief review. It's going to focus on plaintiff, PLF, defendant, DEFT, or sometimes like students like to write it as DFT, defend, DEFD, defense, D-E-F-S, counsel, K-O-U-N, lawyer, L-A-U-R, attorney, T-O-R-N. All right. And then, of course, torn is a long O. All right, so here are your sentences. Which defendants are present? Give a copy to your lawyer. The defendant appeared in court. The plaintiff brings the action, and the plaintiff's attorney must prove the case. The attorney filed the complaint. The attorneys for the defendants moved for dismissal. There were 3 plaintiffs in the lawsuit. The attorneys agreed on the date. Counsel for the defense rested. Have you retained counsel? I think, counselor, that your defense is weak. The plaintiffs had a strong case. Who is going to defend you? The attorney did a good job of defending the defendant. Which defendants have been excused? Mr. Jones defends cases for the insurance company. He defended his position. His lawyer has defended similar cases. The attorney's motion was granted. All right. We'll move right into literary. Literary and jury charge. Actually, you know what? I forgot about my number drill. Sorry about that. We'll do a number drill because I know it's important, and then we'll go to that. I forgot about that. All right, this is going to focus on times. Okay, here we go. We arrived at 4 o'clock yesterday. Be there for dinner between 6 and 7 p.m. The plane is to leave tomorrow at 2:30. I promise I will be at the office by 6:30. The program is airing tonight at 10:30. My flight will arrive at 3:15 this afternoon. Cocktails will be served at 5:30. I think that 8 o'clock is too late. The classes start promptly at 7 a.m. The court was adjourned until 1:45 p.m. The first matinee started at 12 o'clock p.m. Were you there between 10 and 11? I have a 4 o'clock engagement. My mother is always asleep by 9:30. He goes to the dentist tomorrow at 8:45 a.m. The hearing was at 10:15 Friday morning. Everything has to be in the office by 8. I was with friends from 9 o'clock on. All right. Now we'll start our literary and jury charge. Okay. All right. Now this is a narrative answer. And I'm going to I'll start at 60 and then work my way to 80, okay? And then the next one we do, I'll start at 80 and work my way to 100, okay? All right, here we go. Ready? The meeting lasted a very short time. It was maybe 12 minutes or 15 minutes. We all knew what we were there for. As I said, we had already had all these meetings at a prior date. It was just a matter of finding a good time to have all of us get in the same room. There were only a few key points that had to be talked about. We all soon had a meeting of the minds, and we were told Fred Landry drew it up and that we would sign later. From there, we walked out to Alan Henry's office and told Alan everything was great. Then Alan made a number of comments. Well, we left from there and then we went to Fred's office, at which point Charles made a phone call to Matt and told him what had taken place. Fred Landry said, "If you wait, I will draft this up and we can sign it." Charles looked at his watch. In view of the fact that the meeting had taken such a short time, he said he would be able to catch the early evening flight back to Cleveland, and he opted to take that flight. There was some talk regarding how he would sign it, and Fred said that it was possible to sign a counterpart or something, meaning that Charles could sign his copy and I could sign mine. Then Fred would attach them and it would be as if we had signed them together. All right. Moving right into heard in Congress. So I'm going to start at 80, work my way up to 100, And then after that, we'll do some jury charge, okay? All right, here we go. We often hear of the plight of a particular group of farmers. For many of my colleagues, the problem has been how to work with the present program, where a number of growers hold acreage allotments. This is a critical problem, and I fully believe that the ideal solution would be to have a perfectly free market in which all would participate. There are certainly farmers in my own state who would like to gain full access to the present program. I can assure you that this is not an isolated program, and I must say to the farmers in other states the same words that I say to my constituents, and that is that we cannot have one. We do not have an ideal situation. We do not have a perfectly free market, and we cannot have one as long as our sales are dependent upon the ups and downs of a world market. I do believe, however, that we need to get more farmers into the land allotment program, and we need to make that program work as well today as it has worked in the past. This, Mr. President, is the very essence of the proposed compromise. It is a compromise which does not destroy what we have. Instead, it builds on a foundation that we have already built so that we may improve the lot of all the farmers. What we must realize is that we are not in a position which allows us to have total freedom of action. We cannot just start all over with a new program at this point. This is not a football game where we can just start afresh. Mr. President, the truth of the matter is that we seem to be going into the third quarter of this football game, and our team is substantially behind in the score. I know that we can rise to the occasion and score a touchdown. We just need to take a critical look at the program and then put our heads together and fix it. I am sure that we can do it. All right. Moving right into some jury charge. you're going to hear assault and battery, which is S-A-U-B, SAUB. Let's see. In this case, I like to write that as N-I-K. And then if I get the word nick, I would just flag it. In that case, I write knack, N-A-K. In that case, I write neck. And then I flag the other words because they don't come up as often. Let's see here. You're going to hear summation. You could squeeze that. S-M, long A-shun, summation. Let's see. What else are you going to hear? Evidence, EFD. And circumstantial evidence. I don't have a brief for that except for each individual word. So like circumstance, I write circ, S-I-R-K, and then circumstantial, I'll just come back for A-L. Evidence, I write as E-F-D. So that's how I would write circumstantial evidence. And then you're going to hear beyond a reasonable doubt, that's Y-A-R-D. Or you can write it as Y-R-D and leave out the A so it doesn't conflict with yard. Reasonable doubt is initial R, final D. I think. Oh, you're going to hear beyond all reasonable doubt. So then that one you're just throwing in the U, Y-A-U-R-D. All right. All right, here we go. And I'm going to read this, let's see here. At 8, I'm going to start at 80, work my way to 100, okay? It now becomes your duty as jurors in this case involving assault and battery to determine all the facts that have been presented. You have heard the attorney for the people sum up his case. You have heard the attorney for the defense make his summation to you, and you have heard all the witnesses present their sides of the events which took place last December. Evidence is either direct or circumstantial. Direct evidence is evidence that directly proves a fact without the necessity of establishing that fact. Circumstantial evidence is evidence that, if found to be true, proves a fact from which an inference of the existence of another fact may be drawn. Both direct evidence and circumstantial evidence are acceptable as a means of proof. Neither is entitled to any greater weight than the other. You must remember that the defendant is presumed to be innocent until proved guilty. The people must establish beyond a reasonable doubt that the defendant is guilty. What does reasonable doubt mean? It means a doubt based upon reason and common sense. You must be reasonably certain that this defendant is guilty. You must have no doubts as to his guilt. You must feel sure that he is guilty beyond all reasonable doubt. Intent can be shown by a statement of intent made by a defendant, by the circumstances attending the act, the manner in which it is done, the means used, and the soundness of mind and discretion of the person committing the act. For the purposes of this case, you must assume that the defendant was of sound mind at the time of the alleged conduct, which it is charged constituted the crime described in the information. All right. We're going to get right into some Q&A. All right, and I'm going to start with just a strict Q&A, like no colloquy or, no four voice or anything like that. We'll just start with Q&A, all right? And let me give you a word list, okay? You're going to hear borings, B-O-R-I-N-G-S, so borings. You're going to hear adjacent, inspection, visual, determining, subsequent, which you can write as S-W-E-N-T, swent, foundations. So we've got the brief foundation, F-O-U-N-G-S. So foundations, you just come back for the final Z. Patio slab, approximately, initial P, final L. How long, H-O-U-L-G. Had you ever, that's H-U-F-er. Difficulties, so you can use your brief for difficult, D-U-L-T, and then either come back for A-E-Z or long E-Z, either one works. Measurements, property, P-R-O-R-P. Subsequent, I think I gave you subsequent, S-W-E-N-T. At any time, T-N-T. Do you have, you can phrase that whole thing, and then and a half is N-A-F, NAF. Okay, and soil. All right, so this is going to start with, actually it's just defense. All right, and I'm going to read this one time at 60, one time at 80, one time at 100, and that way you can see the different speeds. All right, so we'll start at 60. Here we go, ready? Now, at some point along the line, was there a soil test made? Yes, borings were made. Did you make an inspection of this property when you first went there? Yes. And would you describe for the court the nature of the inspection that you made on this first occasion? The inspection was a visual inspection in which I noted the cracks and the movements relative to the foundations of the building and the difficulties that were developing with respect to the patio slab. Prior to this date, had you ever inspected other homes for the purpose of determining whether there was any soil movement affecting the home and the foundation upon which it rested? Yes. Approximately how long did you spend there on this first occasion? I presume it was an hour or an hour and a half, maybe 2 hours. Did you make or take any measurements on that occasion? Only to note widths of cracks in general and the location. Did you look at the adjacent property and the properties below it and above it and so forth? Yes. Did you make any subsequent inspections of that home after this first occasion? Yes. Do you have an opinion based on your inspection? Yes. Did you examine the foundation plans for this home at any time before you first inspected the house? Yes. All right. I'm going to read it again at 80, okay? All right, here we go. Now, at some point along the line, was there a soil test made? Yes, borings were made. Did you make an inspection of this property when you first went there? Yes. And would you describe for the court the nature of the inspection that you made on this first occasion? The inspection was a visual inspection in which I noted the cracks and the movements relative to the foundations of the building and the difficulties that were developing with respect to the patio slab. Prior to this date, had you ever inspected other homes for the purpose of determining whether there was any soil movement affecting the home and the foundation upon which it rested? Yes. Approximately how long did you spend there on this first occasion? I presume it was an hour or an hour and a half, maybe 2 hours. Did you make or take any measurements on that occasion? Only to note widths of cracks in general and the location. Did you look at the adjacent property and the properties below it and above it and so forth? Yes. Did you make any subsequent inspections of that home after this first occasion? Yes. Do you have an opinion based on your inspection? Yes. Did you examine the foundation plans for this home at any time before you first inspected the house? Yes. All right, so one last time at 100, okay? All right, here we go. Now, at some point along the line, Was there a soil test made? Yes, borings were made. Did you make an inspection of this property when you first went there? Yes. And would you describe for the court the nature of the inspection that you made on this first occasion? The inspection was a visual inspection in which I noted the cracks and the movements relative to the foundations of the building and the difficulties that were developing with respect to the patio slab. Prior to this date, had you ever inspected other homes for the purpose of determining whether there was any soil movement affecting the home and the foundation upon which it rested? Yes. Approximately how long did you spend there on this first occasion? I presume it was an hour or an hour and a half, maybe 2 hours. Did you make or take any measurements on that occasion? Only to note widths of cracks in general and the location. Did you look at the adjacent property and the properties below it and above it and so forth? Yes. Did you make any subsequent inspections of that home after this first occasion? Yes. Do you have an opinion based on your inspection? Yes. Did you examine the foundation plans for this home at any time before you first inspected the house? Yes. All right. And that was, I consider that a little bit more challenging. You know, that wasn't your typical, car accident. I don't know. I felt like it was a little bit more challenging. So hopefully, you did okay with it. All right. Now I'm going to give you some Q&A. It's got 4 voice. I'm going to start at 60, work my way. We got plenty of time. So I'm going to start at 60, work my way into 80, and then 100, okay? All right, here we go. And let's see here. Yep, it looks like plaintiff is questioning. There's a little bit of colloquy too, so it's good practice. All right, here we go. Ready? The people move that Exhibit 3 be received into evidence. We have a stipulation, I think, to the other one. Your Honor, may I ask one other question? Go ahead. As you spoke with Mrs. Rodriguez, did she display any emotion to you? Yes, sir. Describe what it was. Nervous, upset, and embarrassed. Okay, thank you. You're just offering the pictures, not the envelope? I think we have a stipulation. The photographs were contained in that? Yes. No, just the photographs. They are received as Exhibit 3. Thank you. Your Honor, we have a stipulation entered into between the defendant, his counsel, and the people that if we were to call Dr. Bonin, he would testify that he is a licensed medical doctor, licensed to practice medicine in the state of California, that on the 5th of April 2011, in the early AM hours, he obtained 2 specimens from Ann Rodriguez, and that he provided those specimens to Officer Newmeyer of the Santa Ana Police Department. Yes, that's fine. So stipulated? So stipulated. All right. Again, ladies and gentlemen, you may take that as being an established fact. There's another stipulation between the defendant, his counsel, and the people that if we were to call a Mr. Lee Johnson, he would testify that he's with the Santa Ana Police Department, an expert in his field. He obtained the 2 specimens that Officer Newmeyer from the Santa Ana Police Department obtained from Dr. Bonin, and that on the 27th of November of 2012, he examined those. They, in fact, showed that within a 48-hour period preceding the time that they were taken from Mrs. Rodriguez, that she did have sexual intercourse. Yes, it is so stipulated, although he probably would testify that the presence was consistent with sexual intercourse. I don't know. No, there was sperm found on the specimen. It indicated that she had had sexual intercourse. So stipulated? Yes, so stipulated. All right, ladies and gentlemen, that is stipulated. Now, Your Honor, with the other witness who is en route, the people are ready to rest their case. How long do you estimate before the witness will be here? 10 or 15 minutes. All right, then we will have to recess until that happens. Do you have any of your instructions which you are going to file in this case? Yes. Ready to file? Yes. The court would like to see those as soon as they are available. We will take a recess until the witness arrives. Ladies and gentlemen, the court will admonish you not to discuss the case, not to permit anyone to discuss it with you, not to form any opinion about the case until it's finally submitted to you. Thank you, Your Honor. People would call Mrs. Rodriguez. Take the stand, please. State your full name. Spell your last. My name is Annie R. Rodriguez. Rodriguez. Mrs. Rodriguez, you're going to have to make sure your voice is loud enough so all the jurors can hear you. If you will sit close to the microphone, it will work better. Slide right up to the microphone and bend it. I want you to speak to me in the same tone of voice as I'm speaking to you. Okay? Okay. Do you recognize the defendant that is seated at the end of counsel table? Yes. Directing your attention to on or about April the 5th of 2011, a couple of years ago. Okay? Did you see this defendant someplace in the city of Santa Ana? Yes. Tell the ladies and gentlemen of the jury where you were when you met the defendant for the first time. On First and Main. What time of the day or night was it on the 5th of April? It was around 2 or 2:30 in the morning. What happened that brought you and the defendant together? Well, my car stopped and he asked me if he could help me. Were you alone in the car? Yes. And did the defendant approach you on foot or in another car? In another car. Where had you been prior to the time that your automobile stopped at this early AM hour? I had gone to a dance. Were you en route home? Were you headed home at that time? Yes. Did you have children at that time? Yes. How many? 6. What did the defendant say to you when he offered to help you fix the car? Well, he said my car wouldn't be able to start, you know, and I told him if he could give me a push. He said no. You asked him if he could give you a push? Yes, when he asked if he could help me, and he said no, that he would give me a ride home. Did he offer to give you a ride home? Yes. And what did you say? I told him no, that I wanted him to give me a push, and he said no, that he would take me home. And I said, all right, you're going to have to speak very loudly, Mrs. Rodriguez, so everyone in the courtroom can hear you. Did he offer to give you a ride home in his car? Yes. Did you finally agree to ride home? Yes. Now, before you got into his car, were you able to get your car started? No. All right. Now, what happened after you got into the defendant's car? Well, he drove around for a while and he wouldn't let me get out of the car. Did you tell the defendant where to drive you to take you home? Yes. Did he follow your directions? No. He started to drive down First Street and then, I don't know, finally, he just took me around where I live, you know, but he wouldn't let me get out of the car. Did you try a time or two to get out of the car? Yes, but he would just drive faster. What did the defendant finally do while you were still a passenger in this car? Well, he took me down to Oak Street and he stopped in front of a vacant lot and he put a knife on me, on my neck. Did you see the knife? Yes. Did you feel the knife touch your skin? Yes. All right, so toward the end, I would say the last, probably 4 minutes, we were going at 100. All right, so let me unmute. So how did that feel?
No, that feels good.
Good.
Definitely good. You know, it is funny how when we go slower, like at 60, I feel like I mess up more because when we're going faster, my mind just kind of just goes like the, muscle memory.
Yes.
But when we're going slower, I'm like,
Yes, that is so true. And then your mind starts wandering because you have time to think about other things. Yeah.
So it's funny.
Yeah, that's very typical.
Yeah.
Very typical. So do you feel like you're more at the 100 speed or is this more your trail? Like
this is more my trail.
Okay.
I think that, I'm getting to be, I feel like I'm more like 110, 115. And so 120 can feel really, really good at times. And then when there's those multisyllabic words that come in, then I kind of, fumble up, but I can catch up pretty good at 120. So that's where I feel comfortable. But when I did the class last Wednesday, the 160, 120, 140, 160, there were even some times where I kind of surprised myself a little bit where I was just like, it may have been really, really messy, but I feel like I could still stay with it, that I could still get something, rather than being completely blank.
Dropping big chunks. That's awesome. Yeah. So that just goes to show that you're probably now, probably riding now closer to 120, especially like if you type up a test and you can read it, even though it might be sloppy, as long as you can read it, then okay, that's your official speed.
So,
that's awesome.
Yeah, so it's getting there. It's definitely nice to be back into a schedule with the kids back in school and stuff. So definitely been getting more practice time, which is good.
That's awesome. That is awesome. Well, I'm so thankful that you were here today.
Yeah, it's good.
Yay. Yes. Well, then hopefully I'll see you on Wednesday at 9. Okay.
Yes, at 9.
I'm so excited. Yep, we'll see you Wednesday then.
Okay, thank you.
Have a great day.
All right, you too.
Thanks. Bye.